This time we will discuss the directive principles of state policy and health. For introduction, the Constitution of India has provisions regarding the right to health, the obligation of the state to ensure the creation and sustaining of conditions congenial to good health is caused by the constitutional directives contained in Article 38, 39, 39E, subclause F, 42, Article 47 and Article 48A in Part 4th of the Constitution of India. India is a welfare state which seeks to promote the prosperity and well-being of the people. The directive principles lays down socio-economic goals which the various governments in India have to strive to achieve. These principles obligate the state to take positive actions in certain direction in order to promote the welfare of the people and achieve economic democracy. They give direction to the legislatures and the executive in India as regards the manner in which they should exercise their power. Article 36 and Article 51 contains the directive principle of state policy. It has been observed that nutrition, health and education are the three inputs accepted as significant for the development of human resources. Our Constitution also requires the state to ensure health and nutritional well-being of all people. The obligation of the state to provide health care facilities is set out in the directive principles of state policy under Part 4 of the Constitution. These are the principles which should be allowed by the state as the guiding principles while enacting laws and policies, but they are not enforceable in court of law. Directive principle of state policy and health. The term right to health is now here mentioned in the Constitution. Constitution of India guaranteed the right to health as human rights under DPSP, and in late 1970s, the Supreme Court began to give an expanded meaning and scope to term life appearing in Article 21 of Indian Constitution so as to include right to health in fundamental rights and make it enforceable by virtue of the constitutional remedy available under the Article 32 or Article 226 of the Constitution of India. It is a significant view of the Supreme Court that first it interpreted right to health under Part 4, example directive principle of state policy, and noted that it is the duty of the state to look after health of the people at large. In its wider interpretation of Article 21, it was held by the Supreme Court that the right to health is a part and parcel of right to life and therefore are fundamental rights provided under Indian Constitution. In the real sense, the court has played a pivotal role in imposing positive obligations as authorities to maintaining and improve public health. If we only see that provisions, and then we find that some provisions has directly or indirectly related with public health. They direct the state to take measures to improve the condition of health care of the people. The Indian judiciary played proactive role by entertaining public interest litigation, which provides an authority to the judiciary to examine the socio-economic and environmental conditions of the oppressed, poor and the downtrodden people through PIL under Article 32 of the Constitution. The Supreme Court has directed the government to implement the fundamental rights to life and liberty and executed protection measures in public interest litigation, which is under Article 32 of the Constitution. The Supreme Court has directed the government to implement the fundamental right to life and liberty and executed protection measures in the public interest. Likewise, the court also pointed out that fundamental rights are intended to foster the ideal of political democracy and to prevent the establishment of authoritarian rule, but they are of no value unless they can be enforced by resort to courts. But it does not mean that directive principles are less important than fundamental rights, or they are not binding on the various organs of the state. Article 37, especially for states, the provisions contained in this part shall not be enforceable by any court, but the principles therein laid down are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. The reason behind non-enforceability and non-justifiability of these principles is that they impose positive obligation on the state. The government is under several restraints while applying the directive principles. The most crucial is that of financial resources. Hence, a court cannot issue an order for the enforcement of directive principles. Next, Article 38, Subclause 1 directs the state to strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic and political shall inform all the institutions of the national life. The principle reaffirms what has been declared in the preamble, the function of the Republic to secure inter alia, social, economic and political justice. Article 38, Subclause 2 directs the state to strive a minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities and opportunities not only amongst individuals but also group of people residing in different areas or engaged in different vacations. In other words, no person will be deprived of healthy life because he could not afford it. The state must provide facilities and economically better off persons can afford out of his own pocket. Article 38 of Indian Constitution impose liability on a state, and states will secure a social order for the promotion of welfare of the people, but without public health we cannot achieve it. It means without public health welfare of people is impossible. Article 39 talks about certain principles of policy to be followed by the state. Article 39E and F are specifically relating to health. Article 39 Subclause E directs its policy towards securing the health and the strength of the workers. Even men and women and the tender age of children are not abused, and that citizens are not forced by economic necessity to enter avocations unsuited to their age or strength. Now, Article 39 Subclause F lays down that children are given opportunity and facilities to develop a healthy manner and in condition of freedom and dignity, and that youth are protected against exploitation and against moral and immoral abandonment. Both the article aim to protect and safeguard the interests and welfare of the children and young person. The Government of India has evolved a national policy for the welfare of the children. The policy sets out measures which the Government of India seeks to adopt for the welfare of the children and to protect them from cruelty and exploitation. The Supreme Court has shown a great concern for the children and in its various decisions has protected the welfare of children. Lakshmi Kant Pandey versus Union of India. The court emphasized that the welfare of the entire community depends on the health and welfare of the children. Article 41, another important article, requires the state within the limit of its economic capacity and developed it to make effective provision for securing the right to work, to education and to public assistance in cases of unemployment, old age, sickness, disablement and in other cases of undeserved want. Article 42 requires the state to make provisions for securing just and human condition of work and for maternity relief. India has a large number of population working as laborer, and similar legislations have been passed in order to give effect to Article 42. The Maternity Benefit Act 1961 is one of them, which give the women workers a relief during and after pregnancy. Article 43 requires that the state to endeavor to secure by suitable legislation or economic organization or any other way to all workers, agriculture, industrial or otherwise, work a living wage condition of work ensure a decent standard of life and full employment of leisure and social and cultural opportunities. A living wage is a wage which enables the earner to provide for himself and his family not merely the bare essential of food, cloth and shelter, but a measure for frugal and comfort, including education for children, protection against ill health, requirement of essential social needs, and a measure of insurance against the more important misfortunes, including old age. The Minimum Wages Act 1948 is a legislation put to force to give life to the words of Article 43. Article 47 obligates the state to regard as among its primary duties the raising of the level of the nutrition and the standard of living to its people and the improvement of public health. A number of policies and government programs have been implemented to raise the level of nutrition. In particular, the state is to endeavor to bring about prohibition and the consumption except for medicinal purpose of intoxicants, drink and drugs which are injurious to health. The Supreme Court, while widening the scope of Article 21 of the Constitution and Municipal Council, Ratlam versus Vardhi Chand and others observed, the state will realize that Article 47 makes it a paramount principle of governments, that steps are taken for the improvement of public health as among its primary duties. Now, the Supreme Court while reading the Article 21 and 47 together has observed in case of Vincent Pani Kural Langra versus Union of India, maintenance and improvement of public health have to rank high, as these are indispensable to the very physical existence of the community, and on the betterment of this depends the building of society, by which constitution makers envisaged attending a public health. In our opinion, therefore, it is of high priority, perhaps one of the top. In CESE Limited, its sector versus Subhash Chandra Bose and others, the Supreme Court in this case relied on international instruments and concluded the right to health is a fundamental right. It went further and observed that health is not merely absence of sickness. The term health implies more than an absence of sickness. Mental care, health facilities not only protected against sickness, but also ensured stable manpower for economic development. Facilities for the health and medical care generated devotions and dedication to give the workers best physically as well as mentally in productivity. It enables the worker to enjoy the fruits of his labor, to keep him physically fit and mentally alert for leading a successful economic, social and cultural life. The medical facilities are therefore part of social security, and like guilt, engaged security, it would yield immediate return in the increased production, as at any rate reduce absenteeism on ground of sickness, etc. Health is thus a state of complete physical, mental and social well-being, and not merely the absence of disease or infirmity in the light of Article 22 and 25 of the Universal Declaration of Human Rights, international covenants on economic, social and cultural rights, and the light of the socio-economic justice assured in our Constitution. Right to health is a fundamental right to workmen. The maintenance of health is most imperative constitutional goal, whose realization requires interaction by many social economic factors, Poverty, as we have seen earlier, is one of the determinants of health. Hence, if equally opportunities and facilities are given, it will promote health, prevent disease and illness. Reading articles 21, 38, 39, subclass E, 41, 42, 46 and 48A together. The three judges bench of the Supreme Court in Consumer Education and Research Center versus Union of India, while dealing with the rights of the workers in asbestos manufacturing, has concluded that right to health medical aid to protect the health and vigor of the worker while in service or post-retirement is a fundamental right to make the life of the workman meaningfully and purposeful with dignity of person. The Supreme Court, in this case, dilated the theme of social justice, envisioned the preamble and the Article 38. It said social justice is the arc of the Constitution, which ensure life to be meaningful and livable with human dignity. It is a dynamic device to mitigate the suffering of the poor and weak persons, Dalit, tribals and the deprived sections of the society, and to elevate them to the level of equality to life, a life with dignity of person. It further says that health of the workers enable them to enjoy the fruit of his labor, keeping him physically fit and mentally alert for leading a successful life economically, socially, culturally, medical facilities to protect the health of the workers are therefore the fundamental and human rights of the workman. So, in this regard, all related articles and fundamental rights are intended to make the life of the workman meaningful, purposeful. The court further revealed that jurisprudence of the personhood and philosophy of the right to life envisaged in Article 21 of the Constitution enlarged its sweep to encompass human personality in full bloom to sustain the dignity of a person and to live a life with dignity and equality. The health of the worker is an integral facet of the right to life. In that case, health insurance while in service or after retirement was held to be a fundamental right, and even private industries are enjoined to provide health insurance to the worker. Though the Supreme Court of India in a series of judgments has declared the right to health care to be fundamental right, it had not been given due recognition by the state. What is also quite unfortunate is that in a country where poor and marginalized are more in member and these people cannot afford paid services in any government and private hospitals, the state should develop novel health insurance policies at a nominal rates. The court also held that the right is available not just against the state but also against the private employer. Now, in Paschim Bengal, Khet Mazdoor Samiti and other versus State of West Bengal and others. In this case, primarily dealing with the issue of obligation of the state to provide emergency health care to patients, Supreme Court made a general observation of significance that in a welfare state, primary duty of the government is to secure the welfare of the people, and moreover, it is the obligation of the government to provide adequate medical facility for its people. The government discharges this obligation by providing medical care to the persons seeking all avail those facilities. Article 21 impose an obligation on the state to safeguard the right to life of every person. Preservation of human life is thus paramount importance. The government hospitals run by the state are duty bound to extend medical assistance for preserving human life. Failure on part of the government hospital to provide timely medical treatment to a person in need of such treatment result in violation of his right to life guaranteed under Article 21. The court made certain additional direction in respect of serious medical cases, like adequate facilities are provided at the public health centers where the patients can be given basic treatment and the condition stabilize. Hospitals at the district and sub-divisional level should be upgraded so that serious cases be treated there. Basically, facilities are for given specialist treatment should be increased, and having regard to the government needs, it must be made available at the district and sub-divisional level hospitals in order to ensure availability of bed in any emergency. At state level hospitals, there should be a centralized communication system so that the patient can be sent immediately to the hospital where the bed is available in respect of treatment which is required. Proper arrangement of ambulance should be made for transport of patients from the public health center to the state hospitals. Ambulance should be adequate provided with the necessary equipment and medical personnels. Article 48 subclause A obligates the state to endeavor to protect and improve the environment and to safeguard the forest and wildlife for the country. Various environment laws have been passed to the effect like the Environment Protection Act 1986, Air Act 1981, Water Act 1974, so on, as well known socialist. Mr. M.C. Mehta filed a number of public interest litigation for the protection of environment and health. The court has in the case of M.C. Mehta versus Union of India, he said Article 39 subclause E, 47 and 48A by themselves and collectively cause a duty on the state to secure the health of the people, improves public health and protect and improve the environment. The state has to direct its policy towards securing the health and the strength of the workers, men and the women, and the tender age of the children are not abused, that the citizens are not forced by the economic necessity to enter a vocation unsuited to their age or strength, Article 39 subclause E, and that children are given opportunities and facilities to the development in a healthy manner and in conditions of freedom and dignity, and the childhood and the youth are protected against exploitation and against moral maternal amendment, Article 39 subclause F. Article 47 talks about the duty of the state to raise the level of nutrition and the standard of living and to improve public health. The state shall regard the raising of the level of living standards, nutrition, and to improve public health. The state shall regard the raising of level of nutrition and the standard of living of its people and to improvement of public health as among its primary duties, and in particular the state shall endeavor to bring about prohibition of the consumption except for the medicinal purpose, intoxicants, drinks and drugs which are injurious to health, protection and improvement of environment as also made of the cardinal duties of the state, Article 48 subclause A. Directive principle of state policy and health. Article 38 of Indian Constitution impose liability on a state that state will secure a social order for the promotion of welfare of the people, but without public health we cannot achieve it. It means without the public health welfare of the people is impossible. Article 39 subclause E related with the workers to protect their health. Article 41 impose the duty on state to public assistance basically for those who are sick and disabled. Article 42 makes a provision to protect the health of the infant and mother by maternity benefits. In the Indian Directive Principle of State Policy under Article 47 considers it is the primary duty of the state to impose public health, securing of justice, human condition of workers, extension of sickness, of old age, disablement and maternity benefits, and also contemplated further state duty includes prohibition of consumption of intoxicating drinking and drugs are injurious to health. Article 48A ensures the state shall endeavor to protect and impose the pollution-free environment, for good health. Article 47 makes improvement of public health a primary duty of state, hence the court should enforce this duty against a defaulting authority on pain of penalty, prescribing by law regardless of the financial resources of such authority under Article 47. The state shall regard the raising of the level of nutrition and standard of living of its people and improvement of public health as among its primary duties. None of these lofty ideals can be achieved without controlling pollution, inasmuch as our materialistic resources are limited and the claimants are many. The Food Corporation of India, being an agency of the state, must conform to the letter and the spirit of Article 47 to improve public health. It should not allow substandard food grains to reach the public market. The state under Article 47 has to protect poverty-stricken people who are consumer of substandard food from injurious effects. In a welfare state, it is the obligation of the state to ensure the creation and sustaining of conditions congenial to the good health. Thank you.